Welcome back to Constitutional Criminal Procedure. In this lecture, I'm covering remedies for illegal searches, the exclusionary rule. At this point in the course, we've already talked about the other important issues that you must deal with in your Fourth Amendment analysis. We've already talked about the first major issue, which is what constitutes a search or seizure, or whether there has been. We've already talked about the first major issue, which is whether there has been a search or seizure. It's only when there has been a search or seizure within the meaning of the Fourth Amendment must you even inquire into whether or not the search or seizure is reasonable, because the Fourth Amendment prescribes unreasonable searches and seizures. So it must be a search or seizure as it applies to the Fourth Amendment in order for the reasonableness requirement to be present. The Constitution gives you compliance with that reasonableness requirement, which is the warrant. We know that a warrant, a search or seizure without a warrant, is presumptively unreasonable, absent one of the specifically delineated exceptions to the warrant requirement. So if you do not have a warrant, it is presumptively unreasonable. And so that's going to be your second major issue, which is your reasonableness requirement, or whether you have a warrant. We have taken a close look at warrants. We know what the Constitution requires to have a valid warrant, and you have gone through all of your analysis in determining whether or not you have a valid warrant. Because, even sometimes if you have a warrant, even if you have a warrant, it may not be a valid warrant. It may not be supported by probable cause, or it may not comply with the particularity requirement, even though we know that there are exceptions, good faith exceptions to the warrant requirement, but you have to analyze the warrant and go through that major issue. And then after you have dealt with your warrant issue, your next major issue is whether any of the exceptions apply. If you determine that you have a search or seizure within the meaning of the Fourth Amendment and you do not have a warrant, you must next determine whether or not any of the exceptions to the warrant requirement apply. If you have no warrant and you have no exception to the warrant requirement, then you have to determine what remedy is going to be available. Now, keep in mind that this analysis in some scenario is going to repeat over and over again, because the Fourth Amendment may be implicated several times in the course of a person's interaction with the police officer. They may be initially stopped in a vehicle, and then after they're stopped in the vehicle, the police may remove them from the car, search their person, see something in the car, search the car. Based on what they find, it may become probable cause to arrest them, and then they search their person more extensively, and then it may lead to statements and subsequent searches. But you have to determine at each point in which the Fourth Amendment is implicated, and each time the Fourth Amendment is implicated, if i.e. whether there has been a search or seizure within the definition of the Fourth Amendment. If there was no warrant, there must be an exception. If you have no applicable exception to the warrant requirement, then you move on to the remedy, which in many instances is the exclusionary rule. So in discussing the exclusionary rule, which is what we're going to cover here, there are a lot of different areas that are relevant. One is the history of the exclusionary rule. We're going to talk about the scope and application of the exclusionary rule. We're going to discuss the motion to suppress, and we will also talk about the fruit of the poisonous tree doctrine and exceptions. Now, the definition of the exclusionary rule is the prohibition against use of evidence at trial obtained through methods that violate the Constitution. The exclusionary rule is a judicially created remedy. We know that the Fourth Amendment requires that searches and seizures be reasonable, but the Fourth Amendment does not set forth a remedy if search and seizure do not comply with that reasonableness requirement. The exclusionary rule is a judicially created remedy. The courts established the exclusionary rule. Initially, in 1914, in the Weeks case, the exclusionary rule was established and made applicable to federal prosecutions. The Weeks case first held that in a federal prosecution, the Fourth Amendment barred the use of evidence secured through an illegal search and seizure. The exclusionary rule was made applicable to the states in 1961 in the case of Mapp v. Ohio. And in that case, the court held that we hold that all evidence obtained by searches and seizures in violation of the Constitution is, by that same authority, inadmissible in a state court. The court held that without it, prohibition against unreasonable searches and seizures would be a mere form of words. So this is when the U.S. Supreme Court determined that in order to basically try to enforce the Fourth Amendment requirements against unreasonable searches and seizures, that evidence that was obtained as a result of the unconstitutional search and seizure would be excluded from use against the trial. Now, it is extremely important that we understand the purpose of excluding the evidence from trial. And one of the main reasons why this is so important is because later on in this lecture, we're going to talk about situations where the court has held that the evidence need not be excluded. The exclusionary rule should not apply. And in doing so, they look at the ultimate purpose of the exclusionary rule and try to determine whether or not that purpose is furthered by excluding the evidence. So it's very important that you understand the purpose of the evidence of the exclusionary rule in order to understand why there are some circumstances where the evidence should be excluded and some circumstances where the evidence would not be excluded. The purpose is to deter future police misconduct. Police are less likely to engage in unconstitutional searches and seizures if they know the evidence won't be used at trial. Now, keep in mind that the purpose is to deter future police misconduct. And that is important because the Fourth Amendment prescribes unreasonable search and seizures. But if a person has been the victim of an unreasonable search or seizure, then that Fourth Amendment violation has already occurred with respect to that person because that's what the Fourth Amendment protection provides for, that there be no intrusion or invasion into that protection. So theoretically, you cannot remove that injury that they've already suffered. So excluding the evidence is really something that we're doing in order to deter future police misconduct and not to somehow give some sort of advantage to the person who has already had the unconstitutional search or seizure because it is said to have, the damage is done with respect to that person, but we want to deter police from doing it again in the future. Also, you want to keep in mind that as we look at situations where the evidence will be excluded, ultimately we never want to put the police in a worse position than they would be in had the illegality not occurred. We want to put them in the same position, not a worse position than they would be in had the illegality not occurred. Now, another preliminary issue that you want to talk about or think about is the question of standing. We've already talked about standing in great detail, but I just want to briefly mention it again here because when we're talking about who may assert that the exclusion of the evidence, that it is a person who has standing. So we talked about standing, but it is applicable here because the evidence, someone wants evidence excluded, so it has to be an appropriate person who actually has standing. So whether the defendant is the proper party to assert the illegality and to obtain exclusion, i.e., we're asking whether the defendant has standing to assert a Fourth Amendment violation. So it has to be an appropriate person who can raise the unconstitutionality of the illegal search or seizure. Now, we've already talked about how the U.S. Supreme Court, makes that determination as to whether there's been some infringement upon their own individual rights. They cannot assert the rights of another individual and whether there has been an infringement upon their Fourth Amendment constitutional rights. And we've also taken a look at Louisiana's Constitution, and we know that under Louisiana law, Article 1, Section 5 of Louisiana law, it states that any person adversely affected by the unconstitutional search or seizure has standing to raise that in the appropriate court. So even if the police officer if they conduct an illegal search or seizure of someone else's home or someone else's car and ultimately find evidence that they're going to use against this particular person, even if they cannot assert the unconstitutionality in a federal court because there has been no intrusion into their own protected interest, they can raise that issue in a Louisiana state court because they are being adversely affected by the unconstitutional search and seizure, and therefore they would have standing because we know the state courts always give, I'm sorry, the state constitutions are going to always give more protection than the federal constitution. So as we look at the scope and application of the exclusionary rule, the questions that we're asking here is, when does it apply? When does it not apply? To what proceedings does the exclusionary rule apply? In other words, when, under what circumstances, and in what proceedings will evidence unconstitutionally obtained be excluded from the trial? Let's take a look at the Scott case. In that case, the defendant was released on parole and signed a parole agreement allowing search without a warrant. After developing probable cause of a parole violation and a warrant to arrest defendant, he was arrested at a diner. He gave officers the keys to the residence owned by his mother. Following her arrival, but without consent, the residence was searched where the weapons were found. The issue there was whether the exclusionary rule applied to parole revocation hearings, and the court held that we therefore hold that the federal exclusionary rule does not bar the introduction at parole revocation hearings of evidence seized in violation of parolees' Fourth Amendment rights. The justification, ultimately, in that case, the court applied a cost-benefit analysis in order to determine whether or not the exclusionary rule should appropriately be applied, or if the evidence should be excluded from that type of hearing. Now, when we talk about a cost-benefit analysis, we're looking at what costs would be suffered by excluding evidence. Now, most of the time when you're thinking about what costs are there to society in excluding unconstitutionally obtained evidence, in many situations the courts look at allowing a guilty person to go free. If you exclude evidence, you always have that potential cost to society. And there are also, other costs that may be associated with applying the of excluding evidence from trial, and including having to have the proceedings in order to determine whether or not the evidence was properly excluded or not. Okay, so those are just some of the types of costs. And when we look at the benefits of excluding unconstitutionally obtained evidence, the primary benefit that the court will consider is the deterrent benefits. We've talked about the fact that the primary purpose of the exclusionary rule is to deter future police misconduct. So when we're looking at the benefits of applying the exclusionary rule, we're looking at the degree to which it actually would further the deterrence, the deterrent benefit, and help to deter police officers from engaging in that type of unconstitutional activity in the future. Now, applying the cost benefit analysis in the Scott case in the context of a parole revocation hearing, the court held that there were quite a bit of costs to trying to apply the exclusionary rule, including that it would basically alter the entire process. In parole revocation hearings, you don't have judges, you don't use attorneys. So we don't even have the type of setting and proceedings where people who know and understand the law will be able to make those arguments to the court and question the appropriate witnesses and so forth. Evidentiary rules are not used in those types of cases. So all of this would alter the process. Other evidence that's not generally admissible at trial is used in a parole revocation hearing. And the focus of the investigation and hearing would basically change from what we know that you look at, which is violation of parole, versus looking at the police conduct and the constitutionality of the conduct. And also, the parole agents are not in the competitive enterprise of ferreting out crime. They're more in a supervisory position. So in other words, we've talked about this semester the fact that police officers are engaged in the competitive enterprise of ferreting out crime. That's what the courts have said. Because they're zealous and they want to catch the bad guy, they may be a little bit biased on probable cause determinations and so forth. And we want to interject that neutral and detached magistrate in between the police officers and the citizens, and because of that position that they're in. But we're saying here that parole revocation officers, they are not in the competitive enterprise of ferreting out crime, so they don't have that goal of trying to solve the next case or arrest the bad guy that would give them the incentive to want to conduct illegal activity. So all of those are the costs that the court found determined were applicable here. And then when they looked at the deterrent benefits, they ultimately find that the costs outweigh the deterrent benefit. It minimally advances deterring police officers is what they find out here. And they say, well, there are other deterrents like civil lawsuits, discipline for the parole officer. Also, it's the potential use of the evidence in a criminal trial is sufficient deterrence for him. So they held that the cost of trying to apply the exclusionary rule in this type of setting outweigh the benefits. And so that is the test that is used, or that the U.S. Supreme Court has used in determining to which proceedings the exclusionary rule would apply and to which it would not apply, and has ultimately determined that the exclusionary rule would only apply to criminal trials, including juvenile proceedings. But there are a number of proceedings that the courts have held that the exclusionary rule does not apply, and those have been categorized as or termed collateral use exceptions, and they include civil proceedings. The civil proceedings include civil tax and deportation proceedings, criminal proceedings prior to trial, including grand jury proceedings, sentencing hearings, deportation proceedings, parole revocation hearings, habeas corpus proceedings, even in a subsequent perjury trial. Also, impeachment of witnesses. The court has even held that unconstitutionally obtained evidence, although it would not be able to be used in the prosecution's case in chief, if the defendant takes a stand and testifies and impeaches himself, i.e., denies having, ever been in control of the unconstitutionally obtained weapon. The prosecution would be able to confront him with the unconstitutionally obtained evidence in order to impeach him. So, in all of those situations, the court has held that excluding evidence in those situations, in those scenarios, do not further the deterrent benefit of the exclusionary rule, and that evidence may be used. So, if on an exam or even in real life you were to see that there has been some unconstitutionally obtained evidence, but now the evidence, someone is seeking to use the evidence, a state actor, in the sentencing hearing or in the grand jury proceedings, and you are being asked to determine whether that evidence is going to be admissible, then your answer would be that it would not be excluded based on the exclusionary rule, because admitting the evidence in that setting does not further the deterrent benefits. Those are called the collateral use exceptions. Those are the collateral use exceptions. A civil proceeding, the evidence may be used. That's a collateral use of the evidence. Sentencing, deportation, impeachment of witnesses, all of those situations, unconstitutionally obtained evidence may be used. The exclusionary rule only applies to criminal proceedings, including juvenile proceedings. Now let's move on to the good faith exception to the exclusionary rule. In Leon, officers obtained a search warrant using information from an informant that respondents were selling narcotics. The search revealed narcotics and other evidence. The court granted the motion to suppress, finding that the warrant lacked probable cause. At request of the government, the court made clear that the officers acted in good faith, and the issue there was whether the exclusionary rule bars the admission of evidence seized in reasonable good faith reliance on a search warrant that is subsequently held to be defective. So we have a situation where an officer reasonably and in good faith believes that he has a valid search warrant, but it is later deemed to be invalid. So the court held that they resolved it by weighing the costs and benefits of preventing the use in prosecution's case in chief of inherently trustworthy, tangible evidence obtained in reliance on a search warrant issued by a detached and neutral magistrate that ultimately is found to be defective. And they applied the cost benefit analysis here, the same cost benefit analysis that we just discussed, in determining the cost of excluding that evidence and weighing that against the deterrent benefits of excluding the evidence. And the court reiterated that the exclusionary rule is designed to deter police misconduct, not to punish judges who are neutral and have no stake in the outcome. And they're saying punish judges because if the judge approved the warrant and the judge made the determination that the warrant was supported by probable cause, but the judge just happened to be wrong, then excluding that evidence punishes the judge. And when the officer has done everything that he was supposed to do, he's done exactly what we want him to do: to conduct the investigation, prepare an affidavit, and present it to a judge. So excluding that evidence would not deter misconduct on the part of a police officer to exclude that evidence. So the exclusion of the warrant would have no deterrent effect on the judge issuing a warrant. And it, of course, as I stated, it won't deter the police since they are in good faith and they believed that they had a valid warrant and they acted reasonably. And that's what the Fourth Amendment requires, that the officers act reasonably. Now, the exception will not apply. These are several exceptions to the good faith exception. And the exceptions to the good faith exception are basically situations where the officer is not in good faith. If he has reasonable grounds to believe that the warrant issued he had no reasonable grounds to believe that the warrant was issued properly. If the officer includes information that he knows is false or with reckless disregard for its truthfulness. If the judge was not neutral and detached, or if it was facially deficient or lacking any indicia of probable cause. In all these situations, the U.S. Supreme Court has held that the good faith exception doesn't apply. These are exceptions to the good faith exception. Now, there's a case where they held that the judge was not neutral and detached because the judge went with the police officers to execute the warrant. So he became one of the, individuals that was engaged in the competitive enterprise of ferreting out crime. He was not neutral and detached. Um, there was a case where where the judge received so much money per each warrant that he approved. So he's not neutral and detached. He has an incentive. Also, there is the case here where the officers executed a warrant where the space for description of the things to be seized was left blank, and the court held that the warrant was so facially invalid that reliance on it could not be reasonable. So they held that was facially deficient. And in all those situations, if the officer intentionally includes information that he knows is false or with reckless disregard for truthfulness, in all those situations, the officer is not in good faith and the good faith exception will not apply. But provided that the officer reasonably believes that he has a valid search warrant and he's done all the things that he's supposed to do, the the evidence as a result of that warrant, the evidence obtained as a result of the warrant will not be excluded from trial. So remember, the good faith exception ultimately requires that the officer act in good faith. In Shepherd, following a murder investigation, police obtained a search warrant of defendant's residence. The officer showed the warrant to the DA, the first assistant DA, and his sergeant, who all concluded that it was supported by probable cause. After searching for the proper form, it was finally typed on a form designated controlled substances. After making some changes, it was taken to a judge who made additional changes trying to comply with the form requirements. The warrant was executed, and the trial court found that it was invalid because it did not particularly state the things to be seized since controlled substances was on the warrant. The court reiterated the rule, stating that the exclusionary rule should not apply when the officer conducting the search acted in objectively reasonable reliance upon a warrant issued by a detached and neutral magistrate that subsequently is determined to be invalid. So the question here is whether the officer in fact reasonably believed that the search that they conducted was authorized by a valid warrant. The court had no problem finding that they certainly believed the warrant was valid. They also found that the officers were reasonable in so believing. The officers really were reasonable in so believing because the judge said it was valid. They had no duty to disbelieve the judge, or even any reason to think that they should disbelieve the judge. He and the judge did all that they could do to ensure the validity of the warrant here. So the court found that the good faith exception was applicable, that the evidence was admissible, and that applying the exclusionary rule in this context would not serve the function of deterring police misconduct. So it's not applicable to apply or to exclude the evidence. In Matthew, police officers obtained a warrant for arrest of a defendant in search of his residence following an investigation for second-degree murder. The warrants were obtained in Lafayette, the 15th JDC. District includes Acadia, Lafayette, and Vermilion parishes. The search was conducted in St. Martin Parish at defendant's home. The defendant was arrested at 10:47 a.m. and told this to an officer. The search was conducted at 3 p.m. after the officers effectively had knowledge that they were in the wrong parish. Now, the court considered Leon the good faith exception to the exclusionary rule. They also took a look at Article 161 of the Louisiana Code of Criminal Procedure. May violate the procedural rule, but not necessarily the Constitution. And good faith on the part of the officers. They didn't judge shop. They could have gotten a warrant in that parish and so forth. The Code of Criminal Procedure, Article 161, states that a judge may issue a warrant authorizing the search for and seizure of anything within the territorial jurisdiction of the court. So technically, it was not executed properly. The court held the evidence to be admissible. Balancing the costs and benefits of the highly reliable physical evidence seized during the challenged search of defendant's residence, the trial court erred in suppressing it. The court found that the evidence was, in fact, admissible in that case. So when we have this good faith exception, the court has found that it has applied to a substantive deficiency on probable cause when the officer reasonably believed that probable cause exists. And also in Shepherd, we had a form issue. And here in Matthew, in Louisiana court, there's a case in which the courts have held that it was a procedural defect due to the manner in which it was executed in the wrong parish, but the court held that the good faith exception to the warrant requirement applied. Now, keep in mind that we have talked about a good faith exception to the consent requirement and a good faith exception to the exclusionary rule. And so that you do not confuse those, and keep in the good faith exception to the consent requirement, that's when the officer in good faith reasonably believed that the person who gave consent had the apparent authority to do so. Okay, but this is a good faith exception to the exclusionary rule when the officer reasonably relies upon a warrant that is later held to not be a valid warrant. And this is important because it just reminds you of the Fourth Amendment requirement of reasonableness, and the fact that we're always trying to just ensure that the officer's conduct is reasonable. The courts have stated before that we're not requiring that they be right, but we're requiring that the officers be reasonable in their conduct. Let's talk a little bit about the motion to suppress. The motion to suppress is the procedural vehicle to challenge the admissibility of unconstitutionally seized evidence. It is found in Louisiana Code of Criminal Procedure, Article 703, and it states that a defendant adversely affected may move to suppress evidence from use at trial on the merits, on the ground that it was unconstitutionally obtained. Okay? And in the Code of Criminal Procedure, Article 521 gives you the time for filing of pretrial motions. They shall be made or filed within 15 days after arraignment unless a different time is provided by law or fixed by the court at arraignment upon a showing of good cause, why 15 days is inadequate. And it is very important that you try to comply with the time limitations and go ahead and get those motions in timely. You would file a motion to suppress if you're claiming that evidence has been unconstitutionally obtained. In the case of Wallace, the defendant was arrested and a weapon was seized from him on January 15th of 1967. The defendant hired counsel the next day. A bill was filed charging him with robbery with pistols 1 month later. At trial, which began on 4/5/67, as the officer testified about the recovery of the weapon, the attorney objected to the admissibility as illegally obtained. The court refused to entertain the motion to suppress as being untimely filed. And the court discussed the purpose of filing motion to suppress prior to trial rather than during trial. It is to prevent interruption of trials, to avoid the effort and expense of useless trials, to protect juries from exposure to inadmissible evidence and from the delay of having hearings during the trial. So, the jury would have to be escorted out of the courtroom, and the judge would have to convene this hearing, possibly wait for the witness to come in to have the motions to suppress. And you don't want to have to interrupt trials and have the jury waiting to hear the case while these determinations are made as to whether evidence has been constitutionally obtained. And additionally, you can avoid the effort and expense of useless trials. So, for instance, if the prosecution plans to offer evidence of a drug transaction or some drug charge, and the court has already determined that the evidence is going to be excluded, it might result in the case being dismissed, or the defendant, if it's held admissible, the defendant may go ahead and want to enter into some sort of plea agreement. And you don't have to go through the time and expense of trying cases when this is something that could be easily disposed of if we know the outcome of the evidence. So the court, of course, relying upon the applicable Code of Criminal Procedure Articles 703 and 521, they looked at the appropriate time delays. And the court could have granted but did not abuse discretion by denying the motion to suppress filed during the trial, and held that when a motion to suppress is untimely, objection to the admissibility of tangible evidence based on an infirmity in a search or seizure is waived. In the Lawrence case, during arrest of the defendant for vagrancy, he was patted down and the officers found 2 hypodermic needles and other evidence. Defendant claims that since he was arrested pursuant to an unconstitutional statute, the search thereto was illegal. During the trial, the defendant objected to the admissibility of the narcotic evidence, having previously made an oral motion to suppress the pants, which were not offered in evidence at the trial. And the issue is the proper procedure for challenging the admissibility of unconstitutionally obtained evidence. In this case, it was by an objection during trial. And the court held that a defendant could test the constitutionality of a search and seizure only under a motion to suppress, addressed to the judge alone, and failure to raise the issue operates as a waiver of any claim that the defendant's constitutional rights were violated. And keep in mind, the court is saying the proper way in which you are to raise the issue that evidence was unconstitutionally obtained from the defendant, and that it should be excluded from trial, is through a timely filed motion to suppress, and not by an objection during the trial, nor by a motion to suppress filed during the trial. You should try to file your motion within the time delays that are set out by the statute. The reasons for the rule, the court says, is that it would eliminate from the trial before the jury all disputes over police conduct unrelated to guilt or innocence of the accused, to avoid unwarranted delay of the trial and confusion of the jury, to spare the state and defense the expense of a useless trial in cases where a purely legal determination by the judge alone is required, to avoid the necessity of declaring a mistrial because the jury has been exposed to unconstitutional evidence with resulting competitive litigation, and to afford the state and accused advance knowledge of the rules of evidence which must be followed during the course of trial. So they need to know this going into the trial, and whether or not what evidence is going to be admitted or not, and to be able to resolve those issues. Since defendant failed to file his motion to suppress as required by the Code of Criminal Procedure, Article 703A, he could not make his attack upon the admissibility of the evidence by simple objection at the trial itself. In Landry, the trial court granted defendant's motion to suppress. The state filed a motion for rehearing after learning new evidence. The trial court granted the motion for rehearing on the motion to suppress, and the defendant took a writ challenging the granting of the rehearing. The issue is whether the state is entitled to a rehearing on a motion to suppress to adduce new evidence following the grant of a motion to suppress, and the answer is no. Once a motion to suppress is granted, no new evidence on the admissibility of the evidence may be heard by trial court. The state can apply for writs of certiorari. Ruling can't be reversed by the court rendering it. Okay, so that's all on the motion to suppress, which is basically that is the procedural vehicle for challenging unconstitutionally obtained evidence, and that you should do it timely within 15 days of arraignment. And it is not appropriate to wait until the trial to file the motion to suppress or to try to raise it by objection. If you do not file it, then you have waived the right to object to the admissibility of the evidence. Let's talk a little bit about the fruit of the poisonous tree. The exclusionary rule requires not only the suppression of evidence illegally seized, but also of evidence derived from illegally seized evidence, i.e., the fruit of the poisonous tree. So, for example, if there is an illegal search of an individual's car, they may find a list of places where evidence is hidden. They may get a warrant for those places and search those places, and the evidence will be obtained from those places as well. All evidence obtained in the subsequent searches, even though they may be with warrants, they were derived from the initial unconstitutional search. And that particular person or someone else may claim that because the initial search was unconstitutional, that the subsequent obtained evidence is the fruit of that poisonous tree, and that evidence should also be excluded. There are some situations in which a person may be illegally arrested because there's no probable cause or no warrant, and that person may make a statement. Will they implicate themselves and others or tell police where some evidence is? And that person claims that the statements are a fruit of the poisonous tree, or that the subsequent evidence that was obtained is the fruit of the poisonous tree. And so um, usually that person is claiming, or they want to assert, that nothing derived from the initially unconstitutionally obtained evidence should be admissible against him at trial. Now we're going to talk in just a few moments about some limitations that the court has placed on that, but that is the argument that the defendant raises, that when there is some initial illegality on the part of the police, that everything obtained as a result of that, for that initial unconstitutional activity, that it should also be excluded. Now, understanding the fruit of the poisonous tree, you need to understand the difference between primary evidence versus derivative evidence. Once there has been an unconstitutional search, the officers may continue to collect evidence which leads to additional evidence. What was found as a result of the initial unconstitutional search, that's the primary evidence. And then everything that is obtained as a result of the initial unconstitutional search or seizure, all of that is derivative evidence because it is derived from the initial unconstitutional conduct. So the question here is, are there any circumstances when the evidence obtained after there has been an unconstitutional search or seizure may be admissible? Are there any circumstances where that subsequent secondary evidence may be admissible? We know that in most instances, under the exclusionary rule, the definition is that the evidence is going to be excluded from trial, but there may be some instances where the court has developed exceptions to the exclusionary rule where evidence may be admissible at trial. These are your exceptions to the exclusionary rule, where evidence, even though there has been an initial illegality, some initial unconstitutional search or seizure, in some situations, some of the evidence may be admissible. So as you are going back through your Fourth Amendment analysis and you've determined that you have a search or seizure, you have determined that there was no warrant, there was no exception to the warrant, and now you've made it to what is the appropriate remedy. and you have determined that, well, you're asking whether the exclusionary rule should apply because you're in a criminal trial. So in most instances, the exclusionary rule will apply. But there are some limited circumstances in which evidence that is unconstitutionally obtained may be admissible at trial. Exceptions to the exclusionary rule include attenuation or purge taint, inevitable discovery, and independent source. Let's talk a little bit about attenuation or purged taint. And the basic rule here is that where the link between the illegal search or seizure and the evidence obtained is so attenuated that the evidence can no longer be meaningfully considered tainted by or the fruit of the original poisonous tree. Okay, that's your basic rule for attenuation or purge taint. Inevitable discovery is a situation where if the prosecution can establish by a preponderance of the evidence that unlawfully obtained evidence ultimately or inevitably would have been discovered by lawful means, independent of the illegal activity, the evidence is admissible. And there's also the independent source exclusion to the exclusionary rule, where illegally obtained evidence which would otherwise be excluded is admissible if a later lawful search and seizure is independent of an earlier tainted one. The evidence is found by legal means unrelated to the original illegal conduct. So let's take a closer look at attenuation or purge taint. The leading case is Wong's son. In that case, federal agents broke into Toy's apartment without probable cause and handcuffed him. Toy immediately made a statement implicating Yi in the sale of narcotics. The officers immediately went to Yi, who immediately gave them the drugs, then stated he bought the drugs from Toy and Wong's son. So he implicated the person who had named him and another individual. Wong's son was illegally arrested, arraigned, then released pending trial, and several days later, he was also interrogated by narcotics agents after being told of his rights and confessed. The issue here is whether the statement and evidence obtained from Yi and Wong's son, all obtained as a result of the initial illegal arrest of Toy, should be inadmissible against Toy. Or, in other words, how far should the taint of illegally obtained evidence extend to determining whether the exclusionary rule should apply to subsequently obtained evidence? So we already know that when we're talking about the fruit of the poisonous tree, you have some initial illegality, and then you have which is the primary evidence that was found as a result of the initial illegality, but then you also will have evidence sometimes obtained as a result of that. That is the derivative evidence. And then you may have additional evidence obtained as a result of that. And so here the court is looking at how far are we going to extend this before you cut it off as and state that the exclusionary rule should not apply because ultimately because of the rationale that the court stated here. So the court said that the test is to determine whether there is a sufficient connection between the illegality and the evidence to justify exclusion is, and the rule they stated in making that determination is whether granting establishment of the primary illegality, the evidence to which instant objection is made has been come at by exploitation of that illegality or instead by means sufficiently distinguishable to be purged of the primary taint. So when we're looking at that derivative evidence that was found as a result of the primary illegality, we want to know whether or not that evidence was, even if even if you take the fact that there was this primary illegality, was the derivative evidence come at by exploitation of that illegality or by some means sufficiently distinguishable to be purged of the primary taint. The court rejected the but-for test, but held that the prior illegality must have been exploited in some meaningful way. With respect to the statement made by Toy after the illegal entry, that was clearly inadmissible. It was made right after the illegal entry into the house. It was a serious intrusion, likely significant impact on the defendant, based on facts not likely sufficient in an act of free will to purge the taint of the unlawful invasion. With respect to the use of narcotics from Yee against Toy, that was also inadmissible. Seizure of the drugs were a direct result of Toy's statement, already held tainted by the illegality. Since one followed immediately upon the other, there was no break in the chain of causation between the illegal entry of Toy's apartment and the drugs turned over by Yee. So it was obtained by exploitation of the initial illegality, not by some means sufficiently distinguishable to be purged of the primary taint. Now, when it came to the conduct with respect to Wong Sun, one of the issues he wanted to raise was the unconstitutional, the illegal search of Toy's home, but the court held that he had no standing on that issue alone with respect to the admissibility of the evidence being used against him. But the use of his confession against him, even though it was initially arrest without probable cause, the subsequent confession was attenuated from that illegality. He had been released for several days and returned voluntary to the officers to make the statement. The connection between the arrest and the statement had become so attenuated as to dissipate the taint. Okay, so that is the test. Under the attenuation or purge taint, we're trying to determine whether whatever evidence you're objecting to it's so attenuated from the initial illegality as to whether it should now not be excluded under the exclusionary rule. And the test was it by exploitation of the illegality or some means sufficiently distinguishable to be purged of the primary taint. In the Brown case, the defendant was released without probable cause or a warrant. He was then given full Miranda warnings prior to making two inculpatory statements. The Illinois court found that the giving of the Miranda warnings were sufficient to purge the primary taint of the unlawful arrest, and the issue was whether the giving of Miranda warnings alone can purge the primary taint of an illegal arrest. And no, it's not a single factor is dispositive. No single factor is dispositive. Miranda, however, is a factor. So you have these factors. So Brown sets out these factors. You can call them the Brown factors, where the court considers in making a case-by-case determination as to whether the confession was made by exploitation of the arrest or by a person's own free will. Okay, and Miranda is a relevant factor. Whether Miranda rights were given is a factor, but it's not dispositive alone. They will look at the location. Was it given at that original location, or were they taken somewhere else, such as down to the police substation? You look at the time between the arrest and the confession, the presence of other intervening circumstances, the purpose and flagrancy of the official misconduct, considering the policy of the Fourth Amendment. And the state court stated that the state failed to meet their burden here. It was less than 2 hours had passed. There were no intervening events of significance. The second statement was clearly the result of the fruit of the first. It was purposeful. Clearly, the arrest was illegal. And so basically, the court held that Miranda alone will not purge the taint. Just be if police, if there's some initial illegal conduct, and the person subsequently makes a statement as a result of, say, an illegal arrest, that person is going to claim that the statement is being made, that it is the fruit of the poisonous tree, the fruit of the poisonous tree being the initial arrest. That is the primary evidence that we have. And so so you have the state arguing that reading Miranda rights should break the chain, and that the evidence should come in. The statement should come in if you read Miranda, but the court here is saying Miranda alone is not enough. Miranda alone is not enough to purge the taint, but it is a relevant factor along with everything else. Cicciolini, in that case, uniformed police officer on break, was in a flower shop talking with a friend when he saw an envelope with money sticking out of it. He picked it up, looked in it, and also saw policy slips. He asked his friend Lois whose it was, to which she responded, Cicciolini's, and that he had instructed her to give it to someone. Several months later, her testimony was excluded as trial following a motion to suppress, finding that it was the fruit of the unlawful search. And the issue there was whether the testimony of a live witness should be excluded as the fruit of an unconstitutional search, Or is the witness testimony independent of the search and therefore admissible? In coming to its conclusion, the court held that witnesses are not like guns or documents, which remain hidden from view until one turns over a sofa or opens a filing cabinet. Witnesses can and do come forward and offer evidence entirely of their own free will. The degree of free will necessary to dissipate the taint will very likely be found more often in the case of live witness testimony than other kinds of evidence. The court went on to state that the greater the willingness of the witness to freely testify, the greater the likelihood that he or she will be discovered by legal means, and concomitantly, the smaller the incentive to conduct an illegal search to discover the witness. The rules which disqualify knowledgeable witnesses from testifying at trial are serious obstructions to the ascertainment of truth. So testimony here was an act of her own free will. It was not coerced or induced as a result of officers' discovery of the slips. The slips weren't used in questioning her. A significant time lapsed between the illegal search and the initial contact with witness, and a significant time lapsed between the initial contact and testimony at trial. Further, the identity of witnesses and her relationship with the respondent were well known to the investigators, and she probably would have been found anyway, and didn't enter the shop with the intent to find the slips, nor with the intent to find a willing and knowledgeable witness. Applying the cost-benefit analysis, the court held that application of the rule would have the slightest deterrent effect on the behavior of an officer under these circumstances. But the cost of silencing witnesses is great for that type of negligent benefit. So that, again, applying the cost-benefit analysis in determining whether or not the evidence should be excluded or not, and they're finding minimal deterrent benefit in excluding live witness testimony. So the discovery of live witnesses and her testimony was sufficiently attenuated to dissipate the connection between the illegality and the testimony. The live witness testimony is admissible. So you're not going to likely be able to exclude a live witness's testimony claiming that it was the fruit of the poisonous tree. The court did consider all those factors there, but determined that that applying the cost benefit analysis, it did not further the deterrent benefit to exclude a live witness's testimony who comes and testifies on their own free will. In the Hill case, which is a Louisiana case, the officers received a general tip of narcotics activity. They went to that location and observed two men standing in front of an abandoned building. They stopped and the guys walked away in separate directions. They stopped the guys and frisked them, no reasonable suspicion. While interviewing them, they learned of an outstanding warrant on the defendant. He was then arrested and searched incident thereto, where a crack pipe was found. So we have an unconstitutional stop because there was no reasonable suspicion for the stop, and then the search and finding the crack pipe was the derivative evidence that was found as a result of the unconstitutional stop. The issue here is whether the crack pipe should be suppressed as the fruit of the initial illegal stop and frisk. The court lists those Brown factors that we talked about in order to determine whether or not the evidence should be excluded. And it said they applied them to this case to determine whether the search incident to the arrest on the warrant is sufficiently attenuated from the illegal stop. No reasonable stop to allow its admissibility. And applying those factors included the time, between the illegality and the acquisition of the evidence to which instant objection is made, presence of any intervening circumstances, the purpose and flagrancy of the official misconduct, and considering all of the policy arguments behind the Fourth Amendment. Applying those factors, the court says here that the time was negligible. It all happened very quickly. The probable cause provided by the outstanding warrants constituted an intervening circumstance under Brown sufficient to attenuate the taint. The officer would be derelict in not arresting on a warrant. Even if the stop exceeded the officer's authority, the police conduct was not particularly egregious and did not amount to a flagrant abuse of police power. So in this case, the court found that the evidence was admissible. The police officer's discovery of the outstanding warrant was a significant intervening event. The defendant's arrest was based upon probable cause, not derived from the initial stop and frisk. In another Louisiana case, Rahim, the police received a tip from a confidential informant that the defendant and others were selling large quantities of drugs in the hole. They were able to describe the car and license plate number. The police went there, saw the vehicle matching the description, and stopped the car. When the defendant got out of the car, the officer grabbed her purse, searched it, and found drugs in a vanilla wafer box. After the arrest, she consented to the search of the car less than 40 minutes later. Here, the primary evidence was the drugs in the box. The derivative evidence were the drugs and other evidence found as a result of the search of the car. That was the fruit of the poisonous tree. And the issue here was whether Miss Rahim's consent to the warrantless search of her car was so tainted by her earlier illegal arrest and search of her purse as to require the suppression of the evidence seized pursuant to that consent. So here we have a person's initial illegality, and you may have an initial illegal stop of someone or an illegal arrest, and the person subsequently consent to searching their vehicle, searching their home. And again, in that situation, you're arguing that the consent was the fruit of the poisonous tree. And here they're looking at whether that is sufficiently distinguishable from the initial illegality in order to be purged of the primary taint. What must be shown for admissibility? That the consent was a product of her free will and not the result of exploitation of the previous illegality. The factors here, if told that she need not apply, the time between the illegality and the consent, the presence of intervening circumstances, the purpose and flagrancy of the official misconduct are all relevant factors. Analyzing those factors in this case, we are dealing with a relatively short period of time. The temporal proximity, 138 to 208. So a very short period of time between the initial illegal conduct and the subsequent consent. There were no intervening circumstances that occurred during that time. She was continued in custody the entire time and given while she was under arrest at station. So the consent here was not sufficiently attenuated for admissibility. The evidence seized from the car was suppressed. Your analysis of whether the derivative evidence is admissible under the attenuated exception to the exclusionary rule is first, you're primarily trying to determine whether the evidence was obtained by exploitation of that illegality or instead by means sufficiently distinguishable to be purged of the primary taint. In trying to determine whether the evidence was obtained as a result of exploitation of the illegality or means sufficiently distinguishable, you would consider the Brown factors, including the time, the temporal proximity, the time between the illegality and the subsequent, search or whatever evidence that they derived, and you would look at other intervening circumstances. We just talked about a case where the court held that determining that the person had an outstanding warrant was a sufficient intervening circumstances to break the chain, because when you find the warrant, you have some sufficiently distinguishable means that you're arresting him on. It has nothing to do with exploiting the initial illegality in any way. You look at the flagrancy of the police misconduct and other factors. If it's a statement, you would consider whether the person was given Miranda warnings prior to that statement or any other. You would consider the location. All of these are relevant factors in making that determination. So, the subsequent evidence, it could be subsequent searches, it could be subsequent statements, it could be subsequent consent that is given, but in any instance, there you have the defendant claiming that it all goes back, it was all derived from that initial police misconduct, and that defendant is claiming that all of the evidence should be excluded, but at some point the court will cut off that chain and find that it is attenuated, that this particular evidence is so attenuated from the initial illegality that it has been purged of the primary taint, and the exclusionary rule should not apply, and that evidence should not be excluded from evidence against the defendant. Let's move on to the independent source exception to the exclusionary rule. Here, the illegally obtained evidence which would otherwise be excluded is admissible if a later lawful search and seizure is independent of an earlier tainted one. The evidence is found by a legal means unrelated to the original illegal conduct. The leading case here is Murray. In that case, the police made a warrantless entry of an unoccupied warehouse where they observed bales of marijuana. They then left without disturbing the bales. While keeping the place under surveillance, other officers obtained a warrant. They did not tell the issuing judge about the entry, did not rely on any observations in establishing probable cause. They then searched pursuant to the warrant. And there were two issues here. First was whether the object of a search may be admissible when the basis or the source of the search, the warrants, is independent of the illegality, the initial illegality. And also a separate sort of sub-issue is whether the direct evidence of a search may be admissible subject to the exceptions of the exclusionary rule rather than just derivative evidence. Now, application of the exclusionary rule is designed to put the officer back in the same position they would be in had the illegality not occurred. Remember, we talked about this quite a bit at the beginning of this discussion, that with the exclusionary rule, you want to exclude evidence if it would deter future police misconduct. We want to put the officers back in the same position that they would be in had the illegality not occurred, but the goal is not to place the officers in a worse position than what they would be in had the illegality not occurred. Excluding evidence under these circumstances, when the officers have some independent source, completely independent of the illegal conduct, would put the officers in a worse position than they would be in had the illegality not occurred, because since they had some independent legal source, they were going to find that evidence, and we would be putting them in a worse position to exclude it. Evidence would be excluded if the warrant was based on the illegally obtained information, or if it was prompted by what they saw, in which case the warrant would not be an independent legal source. But here the officers it was a completely independent source. They did not include any information that they found in the warrant. I'm sorry, in the initial illegal search. The officers did not reveal the warrantless entry to the judge. They did not include anything they saw. The trial judge did not find whether they would have sought the warrant anyway. But ultimately, that because the warrant was an independent source and was independent of the initial illegal unconstitutional conduct, the court held that the exclusionary rule does not warrant excluding that evidence because it would not deter police misconduct. And with respect to the second issue, the fact that the evidence was the direct evidence of the purported illegality does not preclude application of this exception to the exclusionary rule. Recall that usually you have some initial illegality, and as a result of that, then there's some derivative evidence that they find as a result of that. But here, the direct result of the unconstitutional search and seizure, well, it was the same evidence actually that they had an initial unconstitutional search, and then they had the warrant that was the same evidence with respect to the initial unconstitutional search and seizure. But the fact that it was both primary and not derivative evidence was not a relevant factor, so it would apply regardless of that. So that's the independent source. Okay, so you might see a situation where There may be the independent source could possibly be the officers are going in with respect to a warrant that's not based on something as you had here, or it might have even be an exception where that person might have been involved in a high speed chase while those police officers were there looking unconstitutionally. Some other officers are coming in chasing them with in hot pursuit, and the person runs into the warehouse and they're chased into the warehouse by those officers who, again, were not going in as a result of what the other officers may have seen. It was not in any way based on that. It was completely independent of that, and that's the independent source exception to the exclusionary rule. The inevitable discovery exception to the exclusionary rule here, if the prosecution can establish by a preponderance of the evidence that unlawfully obtained evidence ultimately or inevitably would have been discovered by lawful means, independent of the illegal activity, the evidence is admissible. So they would have to establish by a preponderance of the evidence that the unlawfully obtained evidence would have inevitably been discovered. Then that evidence, again, would be admissible. It would not be excluded based on the exclusionary rule because it would have inevitably been discovered anyway. And the leading case on this, Nix, officers, as well as over 200 volunteers, were engaged in a search for the body of a child murder victim. Prior to finding the body, the officers illegally questioned the defendant about the whereabouts of the body, where he disclosed the location of the body. The officer testified the area in which the body was found was on the map plans that they would have been searching within the next few hours. So it was sort of like those perimeter searches where they have designated areas that they're going to be searching in the next day, and they were able to show that they were going to be searching in that area where the suspect who was illegally questioned stated that the body just happened to be. And the issue here was whether evidence discovered as a result of unconstitutional police activity should be excluded, even though it would have been inevitably discovered absent the police misconduct. And here they used the same rationale that the court used for Murray. The exclusionary rule is applied to deter police misconduct. It is not designed to punish the officers by making them worse off than if the illegality had not occurred. If the challenged evidence would have been inevitably discovered in the course of legal police activity anyway, then exclusion would indeed place the officers in a worse position than if the illegality had not occurred. So, in this situation, the officers have to prove by a preponderance of the evidence that they were, in fact, it would have inevitably or ultimately be discovered anyway. So if they were able to, in this case, because of their map plans, they were able to demonstrate to the court that they were going to look in that area. So they would have found it anyway. So if you exclude evidence that the police were going to find, even absent the police misconduct, the illegal and unconstitutional act, if you exclude that evidence, then you're putting the police in a worse position than they would have been in had the illegality not occurred. But the goal is to put them back in the same position that they would have been in had the illegality not occurred. So this was the first case to recognize the inevitable discovery doctrine. The same rationale here is for the independent source. Okay. Now, so that's three exceptions to the exclusionary rule you have here: the inevitable discovery, the independent source, and the attenuation or purge taint. And in all of those situations, even though you have some initial police misconduct, it does not necessarily mean that the evidence, derivative evidence, or in some cases the primary evidence, will automatically be excluded if you can show that it was inevitably going to be discovered anyway, or if it was obtained by a source independent of the initial illegality, or there is some derivative evidence that is so attenuated that it is purged of the primary taint and should therefore not be excluded based on the exclusionary rule. Now, there's another case I want to just talk about briefly, and that's Hudson, just decided a few years ago, where police obtained a valid warrant, but the warrant was illegally executed because the police officers failed to wait a reasonable amount of time before making a forceful entry into the defendant's home after knocking and announcing their presence. And the issue there was, should the evidence be excluded from trial that is obtained in violation of the knock and announce rule, even though the officers had a valid warrant when they went there. And the court ultimately held that the exclusionary rule does not warrant the exclusion of evidence obtained in violation of the knock and announce rule. And this sort of changed the law because prior to that, this type of evidence was excluded. Because, as you know from our early Fourth Amendment analysis, we know that when we're talking about a reasonable search and seizure, we don't only talk about whether or not, it's supported by probable cause, but we also look at the manner in which the search or seizure is executed. So, that is the same analysis that they use with respect to looking at the amount of force that's used to effect an arrest. And here, the knock and announce is part of the procedure that makes the execution of the warrant reasonable. So the court had always held that violation of the knock and announce rule was an unreasonable search and seizure, and therefore the evidence was excluded. But when they revisited this case in 2009, the court went back to the original purpose for the exclusionary rule, which was deterring future police misconduct. And they really focused on looking at the purpose of the rule and determined whether or not excluding evidence in this context furthered that purpose. And that's one of the reasons why you need to always understand the rationale, the reasoning behind the rule when you're trying to determine whether or not a particular situation is an appropriate situation in order to apply that particular rule. And of course, if we want to deter future police misconduct, then we have to determine whether or not excluding evidence in a particular scenario will in fact deter future police misconduct. And they basically applied the cost benefit analysis in order to make that determination. And again, the cost, we look at the cost of excluding evidence in that particular context, and we weigh it against the deterrent benefit of excluding the evidence. And of course, when they look at the deterrent benefits, they find that it's minimal deterrent benefits, because basically the officers have done everything that they're supposed to do. The officers have conducted their investigation, they've gotten probable cause, they've filled out an affidavit for the search warrant, they've taken it to a judge, gotten it approved, they've got their warrant, they went to execute. And this is what we want police officers to do. So excluding the evidence is not going to make them do anything more with respect to getting that warrant and so forth. But the cost, the court said, would be great because, of course, you're excluding evidence against a person at trial, and then you have the possibility that they would go free. And so because you have these important costs and the minimal deterrent benefit, the court held that the violation of the knock and announce rule should not lead to the exclusion of the evidence obtained as a result of the violation of the knock and announce rule. And I want to put that here, obviously, because it is an application of the exclusionary rule, or an analysis of the circumstances under which the exclusionary rule should or should not apply. And we never know. There may be another scenario that the courts may come up with later on in which they have to reapply that. So with respect to the exclusionary rule, some of the main points we've covered here is that it applies to criminal trials, including juvenile proceedings, but there are a number of collateral use exceptions that allow the use of unconstitutionally obtained evidence, even some pretrial proceedings and other types of civil proceedings and so forth. So if you see any of those situations where unconstitutionally evidence has been, that where the court is seeking, or the prosecution or a party, the state actor is seeking to admit the unconstitutionally obtained evidence, then the evidence will come in trial. You also have to keep in mind the good faith exception to the exclusionary rule, where the police officers reasonably rely on a warrant later held to be invalid. We know that there are exceptions to this good faith exception where, for the most part, it applies when the police officers are not actually in good faith. For instance, if the warrant is facially invalid, or if they include information that they know was not true, or they could have reasonably determined whether or not it was true. In those situations, then the officers are effectively not in good faith, and the good faith exception does not apply. Also, the good faith exception also applies to a statute that an officer relies upon that is later held to be invalid. There are a number of cases out there, one of which um, the officers relied upon a statute that allowed him to go upon property and run VIN numbers. I believe that was the case. And in that situation, the officer found a number of vehicles. I believe they had been stolen, but he was conducting the search on the property without the warrants. And so they later found that statute that allowed him to do that to be unconstitutional, but the officer was reasonable in relying upon the constitutionality of the statute, and the same good faith exception applied where the court held that the officer was reasonable. So the good faith exception applies both to a warrant later held to be invalid or a statute that is later held to be unconstitutional. If the officer is in fact in good faith and none of the exceptions apply, because the exceptions also, there are exceptions to the good faith exception with respect to a statute as well, provided none of those exceptions to the good faith exception apply, then the evidence would not be excluded. We know that the proper procedural vehicle for bringing this evidence is or for bringing the claim that the evidence was unconstitutionally obtained and should be excluded is the motion to suppress, filed within 15 days of arraignment, not at the trial, not by a mere objection. In those situations, you deem to have waived the right to exclude the unconstitutional evidence. And we've also covered the exceptions to the exclusionary rule. So that is the last of the major issues under the Fourth Amendment. You will always look for each instance in which the Fourth Amendment has been implicated. Every time there is an additional search, or whenever you have an additional seizure, if there was no warrant, you have to determine whether or not an exception to the warrant requirement applies. When you're looking at the exceptions to the warrant, you have to know all of the requirements for the application of that exception, i.e., looking at plain view, you have to be sure that the officers are where they have a right to be and from which they have a right of access to the thing, and it is immediately apparent that it's evidence of crime or contraband. And then, after looking to determine whether all of the requirements are met, you also looking to determine whether or not the officers remained within the scope of that exception. So with respect to the plain view, the officers, cannot conduct any additional search in order to make a determination as to whether the thing is actually immediately apparent that it's evidence of a crime or contraband. So if it is some, drugs that's on the table and the officer can see that it's immediately apparent that it's contraband, then he may seize it. However, if he has to conduct some additional search, such as calling in the equipment in order to check the VIN numbers, or if he is patting the person down and he finds a container and has to look in the container, then he's beyond the scope. So you have to make sure that when you're going through the exceptions, you know all the requirements for the exception, as well as you have to make sure that the officer remain within the scope of that particular exception to the warrant requirement in order for it to apply. Once you've gone through the exceptions, if you have no warrant and you have no exceptions, then you have to determine what is the remedy, the judicially created remedy for violation of the Fourth Amendment protections against unreasonable searches and seizures. And of course, that is the exclusionary rule, the exclusion of the evidence from use against the defendant at trial. But there may be one of the exceptions to the exclusionary rule where the unconstitutionally obtained evidence may be admissible if it was obtained by some independent source, or it would have inevitably been discovered anyway, or if it was attenuated from the initial illegality. And so when you've gone through that analysis, that will be your final determination. And in your Fourth Amendment analysis, keep in mind that the question is primarily going to be the same question. The defendant would like to exclude the evidence. Upon what basis will he claim that the evidence should be excluded? How will the court likely rule and why? So most of the evidence begins there. And when you're asked about upon what basis will he claim the evidence should be excluded, you should begin with the defendant will claim that the evidence was obtained in violation of his Fourth Amendment protections against unreasonable searches and seizures because the evidence was obtained without a warrant nor an exception to the warrant requirement. And so then you would go through your analysis then to state why it was a search or seizure, talk about the warrant if there is one and whether it's valid, and if not, the exceptions, and then the exclusionary rule. That is your lecture on the Fourth Amendment analysis.